May I please your Lorships?
Yes.
Well, I want to make you mention for an urgent application which has been filed on 25th of May and it has not been listed. So please, your Lorships, have it at 2 p.m., my lord.
Tomorrow? You want it tomorrow?
Today, my lord, at 2 p.m.
Today? No,
Yes,
no, not possible today. Tomorrow.
my lord, this was very urgent, my lord. There's an injunction matter pending. My lord, it's very urgent. Otherwise, I would not have made the request, my lord. Kindly consider, my lord.
What is the matter about?
The matter is about the vacation of an, my lord, injunction order without, my lord, hearing me on the basis of a letter which was written by the deputy commissioner to the, my lord, district judge of Mon, my lord. And that is the matter by which my injunction was vacated, my lord. Now, my lord, I am apprehending that my property will be taken over, my lord, by force. And that is why I am before your lordships, my lord.
Not at 2, because we have a meeting. This court will not be sitting at 2. So we'll
So
see.
at the end of the list, my lord.
Have you given the. Yeah.
Yes, yes, all the particulars have been given, my lord. It has been filed on 25th.
Okay, okay. Yes. Yes.
All right. I am deeply obliged.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 14. Lordship, I have received the amended copy, so kindly allow 3 weeks' time to file my reply.
2 weeks.
3 weeks, Lordship.
Amended petition.
Yes, yes.
Learned counsel for the respondent.
Yes,
For
Lordship.
the respondent, Mr. Tushi Tamjan Ponganer submits that he has received a copy of the amended petition and would like to file a reply to the same. No, affidavit in reply to the same. So accordingly, list the matter after
3
2
weeks,
weeks.
Lordship.
Yes.
Much
Learned counsel for the petitioner, Mr. Medover, is present. Yes.
obliged.
Mr. Lordship, please allow me to mention move one unlisted item bail application. Here the fact is, after my detention order was quashed by the Honorable High Court, I filed default bail in the district court. But the district court, Honorable District Court, have rejected the default bail application on the ground that the detention period which I have served will not be counted for the default bail. So this Honorable Court have also passed similar
When did
order.
you file it?
I filed in the morning, so it's a matter came to me after regular better mistake.
Tomorrow. If you file it today, then let it come up tomorrow.
Then, my lord, I want to
Melanie,
mention,
please, yes.
I beg to mention here item 11. Item 11, I have instruction to appear on behalf of the private respondent. So I pray for 2 weeks' time to file my power and affidavit.
Learned counsel,
Item 11.
Mr. Pakrin Chapu submits that he has received instructions to appear on behalf of the respondent number 2.
Three, private
Or
respondent.
respondent number 3. Informant.
Yes,
He is the informant, respondent number 2/informant, and prays for 3 weeks' time to obtain instructions and to file his Vakalatnama. So, list after 3 weeks is prayed for. What about petitioner? None appears for the petitioner when the matter is called. Yes.
May I please, Your Lordship? Lordship, I beg to mention hearing item 19. Lordship, I pray this matter can be, if this matter may come up after next week, Lordship.
Learned counsel for the appellant prays for listing the matter next week. List accordingly. Yes.
Much obliged, Lordship.
Please, Your Lordship, I beg to mention item number 7. Lordship, the leading counsel Kim Piana is at disposal, so if this matter may kindly be listed after 3 weeks.
Ms. Such and such learned counsel makes a mention on behalf of the leading counsel, Ms. Kim Penyu, who is stated to be
At disposal.
indisposed today, and prays for listing the matter after 3 weeks.
3 weeks.
So, list after 3 weeks is prayed for. Learned counsel Mr. Intiwapang is present for the respondent 1. Yes. List after 3 weeks.
Lordship, I also beg to mention item number 17 with the same prayer.
Same prayer. Okay, 17 also same prayer. Here also Intiwapang for respondent number 1.
Lordship, and item 21 with the same prayer.
Item 21 also after 2 weeks.
3 weeks.
3 weeks after item 21 also after 3 weeks on the prayer of the here it will be for the respondent. The prayer of the counsel for the respondent Counsel for the appellant, Mr. Intiwapang, is present. Yes.
Lordship, I would like to mention item number 9. Lordship, may this matter be listed after 3 weeks. We are yet to file an IA here in this matter
IA for
for seeking permission for withdrawal of the 50%.
learned counsel, Mr. Intiwapang, appearing for the respondents, prays for listing the matter after 3 weeks in order to enable him to file an IA for withdrawal of the deposited amount. So, list after 3 weeks is prayed for. So, Mr. Medo Vero for the appellant is present.
Obliged.
Oblige me. Lordship, I beg to mention item number 5, my lord. First of all, the consensus prayer if this matter can be listed after 2 weeks, my lord.
After 2 weeks.
Yes, my lord.
On the prayer of the parties, list the matter after 2 weeks.
Lordship, this is the interim.
The interim order passed earlier shall continue till the next date.
Oblige me.
Yes.
Yes, Your Lordship. I beg to mention item number 4.
4.
Yes. I've received the copy of filed by the government on behalf of respondent number 1. So kindly grant me 3 weeks time to file a reply.
There are 4 respondents here. So, whose affidavit?
On behalf of respondent number 1.
1.
Yes.
Learned counsel for the petitioner, Ms.
Mention.
Senior appearing for the petitioner submits that she has received a copy of the affidavit filed by respondent number 1 and would like to file a reply to the same. List after
3 weeks.
3 weeks as prayed for. Yes. You are appearing for respondent? 1. Okay, on behalf of Bishop Pray.
Bishop Grace.
Terchila appears for respondent number 1 on behalf of Bishop. Yes.
Obliged. May I please, Your Lordship? Your Lordship, I beg to mention item number 2. On behalf of Livika, Your Lordship, the affidavit has been sent for vetting, so this matter can come up on Thursday.
Affidavit sent for
last time-
vetting.
Yes, Your Lordship. She received instruction just on Friday, and it has been sent for vetting.
So when will she file? Within this week?
Yes, Your Lordship. So she had requested the matter may come up on Thursday.
This Thursday?
Yes, Your Lordship.
Thursday. Just a few days.
Obliged.
Learned counsel for the petitioner, Ms. Zetzi Momi is present. Ms. A.A.M.E. submits that Ms. Levika, the learned counsel appearing for the respondents, all the respondents, just say respondents, will be filing the affidavit by Wednesday. Give the data accordingly. List the matter on Thursday will be 4th. Yes, 4th June. Okay.
Your Lordship, for item number 6, here the matter, on behalf of Livika, Your Lordship, here also, the matter is under consideration and is placed before the PNR. So if it can come up after 3 weeks, Your Lordship.
May I please, Your
Under
Lordship?
consideration.
Yes, Your Lordship.
Lordship, my senior has some submission to make, so let the matter maybe call up, Lordship.
Okay, you just wait then.
Yes, Your Lordship. Much obliged.
For motion, item number 1.
My pleasure, Lordship.
Yes.
Well, this is the contempt petition directed against the order dated 25/6/2025 at page 50. The background of the case, my lord, is the matter relates to, my lord, the Josama to Kingmay, which is commonly known as Kohima bypass. The claimants or the affected families, they have approached this High Court saying that the Nagaland Acquisition Act is not applicable, rather, my lord, 2013 Act is applicable. So that was the issue in the writ petition. And the Honorable Single Judge was pleased to, my lord, grant the relief. Against that, the state has filed an, my lord, appeal. That is writ appeal number 6 and writ appeal number 7, my lord. And perhaps the hearing of the said writ appeal is been concluded. So far as the NHIDCL is concerned, my lord, we have filed the IA that whatever be the result, my lord, will be abide by that. But then the construction of the road should be allowed to go on, my lord. Accordingly, the instant order has been passed, my lord, that is at page 50. And the relevant, your lordship, may come to page 59.
59, yes.
My lord, the paragraph 2. By filing this application, the National Highway and Infrastructure Development Corporation, represented by the Executive Director P, the seeks appropriate direction to the opposite party to take necessary measures to enable the applicant to resume construction of Kohima bypass road connecting so and so during the pendency of the present appeal. Now, Your Lordship may come to my lord, next page, my lord, page 60, paragraph 5. So far as the government is concerned, my lord, it has been said, page 60, paragraph 5.
Yes, that full cooperation and such and such.
Yes, to the respondent, state has assured full cooperation and state that all effort will be made to maintain law and order. Now, so far as the writ petitioners or the private respondents or the claimants are concerned, my lord, for them in paragraph 6, they said that they are not obstructing and they are not going to do it, my lord. The counsel for the respondent number 6 to 67 petitioners in the writ petition has submitted before this court that they are not obstructing the ongoing construction of the road and undertake that they shall not cause any obstruction to the construction activities. So a consensus order and direction has been issued in paragraph 7 onwards at page
They
61.
are now obstructing. What are they doing now? Are they obstructing?
Now, my lord, they are still, my lord, encroaching, my lord, the hindrance have been created and we have submitted representation after representation before the deputy commissioner to come and take action compliance of the order. Now, finally, he has, my lord, issued an order saying that since the claimants have not received the compensation, so the land is not government, so they cannot, my lord, take appropriate action under the eviction law available to the state. But while this honorable court has specifically directed the district administration to take all measures, my lord, is a very categorical, my lord, in paragraph 8 and 9, if I am permitted to read, my lord. The state government and its instrumentalities, including the deputy commissioner and the local police authorities, are directed to ensure maintenance of law and order and to extend all necessary protection and cooperation to the contractor and implementing agency to facilitate unhindered progress of the project. The Deputy Commissioner and the Superintendent of Police and the concerned department shall personally monitor the construction and take immediate action on the complaint or obstruction of law and order issued relating to construction work. Now, representation have been submitted at page 65 and the DC informs at page 70. Lordship may kindly see how the act has become contempt of this honorable court, page 70.
Okay.
And then, my lord, again, I have submitted representation. Then again, the same thing has been reiterated at page 77. So at this stage, my lord,
Same
my
reply.
lord, yes, my lord, notice may be issued, my lord. Firstly, the private respondents who are aided respondent number 2 to 63, although they have, my lord, given an assurance, rather they said that they are not encroaching nor they are going to obstruct it. Some of them are still there. And then, my lord, so far as deputy commissioner, my lord, he is not taking, my lord, action and saying that, my lord, since compensation is not received by the claimant, so the government, the land yet to be government land for, my lord, taking recourse to the eviction law, madam. So,
Yeah,
lordship may issue
I
notice.
remember this case, the writ
Lordship,
appeal.
lordship, lordship.
So actually, as per the Acquisition Act, the government has not done anything.
Malad, in fact, under the Nagaland Malad Acquisition Act, this moment Malad Section 11 notice has been issued, automatically the land has to the state government. That notification I have Malad annexed as Annexure A at page 29.
That
Malad,
means, I think we found that it was not issued to the landowners, but only to the village council. Where is that page?
Malad, page 29. Malad. It is for general information. Malad.
Yeah, this is anyway, we'll issue notice.
Lordship.
New Councillor Mr. PG Saiki appearing for the petitioners. So, by filing the instant application, under section 11 and 12 of the Contempt of Courts Act, read with Article 215 of the Constitution of India and the rules framed under the Gauhati High Court. The petitioner has alleged willful disobedience of this court's order dated
25/6.
25/6/2025. No, wasn't this a division bench order?
Yes, yes, my lord. It is passed in my lord, ISC number 98 of 2025, my lord.
So shouldn't it come up before the division bench?
Well, it's a contempt, my lord. The jurisdiction would, my lord, come before this court also.
Okay.
Civil contempt, my lord. Criminal contempt, my lord, division bench jurisdiction.
For willful the disobedience of this order, date of this court's order dated 25/6/2025, passed in IA Civil 98/2025, arising out of Writ Appeal 6/2025. Stop. Para. Learned Counsel submits that by the order dated 25/6/2025, the state government and its instrumentalities, including the Deputy Commissioner and the local police authorities, were directed to ensure maintenance of law and order and to extend protection and cooperation to the contractor and implementing agency to facilitate the unhindered progress of the project. Stop. Further, the Deputy Commissioner and the Superintendent of Police were directed to personally monitor the construction and take immediate action on any complaint of obstruction of law and order issue relating to the construction work. Stop. It is further submitted that the private respondents number 2 to 63 had also submitted before the court that they are not obstructing the ongoing construction of the roads, and they had undertaken that they shall not cause any obstruction to the construction activities. Stop. Therefore, the order dated 25/6/2025 was a consensus order. Stop. However, the respondents 2 to 63, where is that stated in your pleadings? Which para that they are obstructing? Where have you stated
Lordship, my lord, I'll just check.
that?
My lord, paragraph 12. Page 18.
Okay. However, the learned counsel submits that the private that there are some, don't say private respondent, there are some pending unresolved issues / hindrances affecting the progress of Kohima bypass, open bracket, package 1 to 4, close bracket, for which the petitioner had requested the authorities, the state authorities, to that letter to page 70, authorities to remove the standing structures which were creating a hindrance. And thereafter, a letter dated 23rd September 2025 had been, no, not 25th. The letter written by NHI this year, who is that? Annexure G.
Intimating the,
Yes, intimating the DC.
yes, my lord, the firstly, my lord, it was on 31/7/25, page 65.
Yes, by letter dated 31/7/2025, had written to the Deputy Commissioner.
And lastly, on 13/1/2026.
And also by letter dated
13/1/2026.
1/13.
1/2026, page 74.
Yes, 13/1/2026 had also issued another reminder to the Deputy Commissioner. However, the respondent number 1 / Deputy Commissioner had replied to
Page
the
17.
petitioners that the stretch of land is unacquired by the government as of now, and therefore not a public land, and hence the issue of eviction notice is not tenable as per the provisions of the Nagaland Eviction of Persons in Unauthorized Occupation of Public Land Act 1971. Stop. Para.
This is again reiterated by letter dated 15/1/26 at page 77.
Stand was again read
Reiterated.
by the Deputy Commissioner Kohima, Nagaland, right, letter dated
15/1/2026.
2026. Stop. Para. Being aggrieved, the petitioners have come before this court. Stop. Issue notice returnable in 4 weeks. Stop. The petitioner shall take steps for service on the respondents number 1 to 63 by speed post as well as usual process within 3 working days from today. List
Such.
of 4 weeks. Yes.
Well, may I pray for a date, my lord, if not inconvenient, my lord, on 27th of July, my lord. 27th of July, my lord.
On 27th.
Obliged. Highly obliged.
Yes, my lord.
Well, I am assisted by Advocate A. Susi, my lord.
Assisted by A. Sushil. A. Sushil.
Yes, my lord.
Obliged.
Prohibitions, item number 3.
May it please your Lordship, on the last occasion, we have forwarded her case to the committee for regularization. However, the committee formed by the PNR department, they rejected her case, saying that the matter is sub judice before the court. I don't know what is the matter with the committee. So again, on 29th of May, we sent it to the PNR saying that there's nothing matter before this court. And to take up her case for regularization at the earliest, Lordship. So I pray that some time may be granted to us.
Has it been sent back to PNR?
Yes, on 29th, we have sent it to the PNR, but that copy was sent only through to me by,
No, but you have to file it in the form of affidavit, no? All
Lordship.
this.
Otherwise also without affidavit also, because on the last occasion I can,
Or else you give a copy.
yes,
to
yes.
the
Lordship,
petitioner.
then, this may be the last chance. And if they are not, if they don't comply with the directions of this honorable court, personal appearance may be
The
called for.
problem here is that I think the direction was for consideration.
Yes, yes.
They have even gone
Consideration.
to the extent of the Supreme Court, your Lordship. They have taken all available avenues to them. They, after the single bench disposed of this petition, again they approached the single bench for a review. It was dismissed. Then they filed a writ appeal. It was dismissed. Then they went to the Supreme Court. It got
That is also
dismissed.
dismissed.
Now this is the position. There is no way for them to, other than to regularize the service of the petitioner.
Petition is disposed of with a direction to the respondents to consider the case of the petitioner for regularization in terms of the memorandum dated 18/2 to the. Okay, so initially also the petitioner's case was left out.
Yes.
Left out.
Yes, the contention of the government is that she did not participate. She did not participated in the screening committee because even in her affidavit, she
but that is
admitted.
all over
Yes,
now.
yes, but she
No, that
admitted
is all
that she was late. Lordship.
No, she appeared.
See, this is the one, the rejection from the screening committee. They examined her case and they returned back for the reason that the matter is sub judice before the court. That's the view of the screening committee. So again, on 29th of May, the department, they wrote a letter to the PNR department to take up the matter.
You inform them that the contempt is pending.
Exactly, and I have
Yes.
given my opinion also in my letter.
Ms. V. Shukri Leonard, additional AG, representing all the respondents, submits that The case of the petitioner had been forwarded to the screening committee in the Department of PNAR for regularization. So, however, by a letter dated 8 May 2026, the PNAR department wrote to the Department of School Education stating that the petitioner's case cannot be taken up under the policy, under the OM dated under the OM dated. No, see, the court direction was to consider under 18/2/2004.
But that OEM was already no more in existence. Already
Okay,
questioned
okay.
by the this honorable division bench. That was questioned, set aside.
Oh, this 18/2/2004.
For which reason
yes,
we filed a
yes.
review, the review was dismissed, again appealed, it was dismissed, yes.
Okay, it cannot be considered under the PNR department's OM dated 16/3/2024, as the policy does not apply to appointments that are sub judice. Stop. However, the matter has now been clarified and the case of the petitioner has again been processed to the PNR
Yes,
department.
on 29th May.
On 29th
May
May
2026.
29th May 2026. So, therefore, the learned council prays that the respondents may be given another
3 weeks
3 weeks
of,
time. 3 weeks time to comply with the direction of this court. No, the file has to be processed and
Your
that-
Lordship, it is okay, but
because
it's so many,
ultimately-
yes,
no,
so
yes,
many
yes,
years
no, I
have passed, and
understand.
they are playing all these games. It is, they even went to the extent of approaching the Supreme Court. It was dismissed. All,
That is a different thing,
Yes.
but coming to an understanding that it is sub judice and therefore not applicable, that is simply
Your Lordship.
non-application of mine.
yes, Your Lordship, let them have sufficient time, but this time, if no concrete result is there, then.
We'll give them 4 weeks time, okay,
Yes.
4 weeks time
Yes,
to
4
comply
weeks.
with the direction
And
of this
if-
court.
if
And
nothing
it is
happens,
made clear
yes.
that no further extension shall be allowed. Stop. List after 4 weeks.
Your Lordship.
my lady, I may be allowed to
Yes,
take
yes, learned counsel for the petitioner, Mr. Tongpok Pomono is present. You give them a copy also?
Yes, I'll give it to you. I'll give it to you.
Yes.
My please, Your Lordship. Your Lordship, I inform that the matter is before the PNAR OM branch, Your Lordship, for consideration. So another 3 weeks may be granted, Your Lordship.
This is also regularization.
Yes, Your Lordship, regularization.
Lordship, here what has happened is that the petitioner was appointed on compassionate basis. However, she was appointed not appointed on regular basis, which is why this honorable court was approached in 2021. Then in 2023, my Lord Justice Nelson Silo, who was sitting as civil judge, directed that the petitioner may be given regular appointment since she was appointed on compassionate basis. Now, after that, this contempt proceedings was initiated towards the end of 2023. It's already 2026, and they have, of course, submitted, to be fair, 2 or 3 letters saying that the case of the petitioner is actively under consideration. The latest was on 4th of May 2026, which is addressed to my learned friend.
Yes, 4/5/26.
Yes, my lord. However, till that, the petitioner has already retired. When she has filed a petition in 2021, she has retired in April 30th.
No, but if regularized, all the
Yes, my lord. So
related
I only pray that
benefits.
the time sought by my learned friend
You're
may be
asking for
granted.
3 weeks.
Yes, Your Lordship.
However,
But make sure that it is done.
Yes, Your Lordship.
if by the next date, if the matter is not considered, then
We'll see
Yes.
if whether we have to call for personal
yes,
appearance or not.
that may be reflected.
Yes.
That whether it will be his personal attendance is required or not will be considered on the next day.
This was filed in 2023.
Yes, Your Lordship.
Yes.
The contempt
I admit,
petition.
yes, Your
Yes.
Lordship.
Learned counsel for the petitioner, Mr. Santiago is present. So, the instant application pertains to non-compliance of the order dated 28/3/2023 passed
Lord.
in WPC 355 of 2021, wherein a direction was given to the respondents 2 and 3 to regularize the service of the petitioner against any grade 4 post or equivalent post as expeditiously as possible, and at any rate within an outer limit of 4 months from the date of receipt of a copy of the order. So, the instant contempt petition was filed on, when was it filed?
27/5/2024.
27/5/2024. Stop. Several adjournments have been granted to the respondents to file their affidavits and to comply with the order of this court. Stop. Today, when the matter is called, Learned Counsel Miss Livika Sumi, appearing for the
If I may,
for
Your Honor.
all.
Yes, Your Lordship.
My lord, if I may, respondents 2 and 3, they are ready
Yes,
to
Your
comply with this honorable court
We have
order.
already done that
Yes.
part.
Yes,
It's
yes,
before
It's
the
just that
PNR.
the
I know.
PNR, the respondent
It
number
is the
4.
PNR,
Yes, yes. They are causing hurdles, unnecessary hurdles. They are saying that they are unable to trace the one office memorandum after another, whereas I have already served copies of the office memorandum.
But have you completed the
Yes,
Yes, Your
PNR
Lordship.
respondent number 4.
later?
Yes,
Yes,
Your Lordship.
yes. Respondent number 4.
Ms. Viveka, Learned Counsel, appearing for all the respondents, submits that the matter has already been processed by the respondent number 2 and 3.
My lord.
And it is now pending with the Department of PNAR / respondent number 4.
Yes, Your Lordship.
She submits that the case of the petitioner is under consideration, and therefore she prays that another 4 weeks' time may be given to the respondent number 4 to comply with the direction of this court. So, since this is a matter pertaining to the year 2023, and the instant application has also been filed on what did I say, 17 on
I'm sorry, Your Honor, my lord, I have filed the contempt petition of 14/12/2023.
14/12/2023.
Yes.
Okay, you then delete that earlier one. 14/12/2023, comma, this court grants another 4 weeks' time to the respondents to comply with the direction of this court, and on the next date, if the same, if the compliance is not shown by the respondents, this court shall consider as to whether the personal appearance of the respondents shall be.
Respondent number 4.
Respondent number 4 shall be necessitated. List after 4 weeks.
Oh,
Deeply obliged.
much obliged.
My lord.
Then,
Yeah,
yes,
please, my lord. Lordship, we would like to withdraw the contempt
withdraw.
because the respondent has filed with appeal. Then the matter came up consideration before your lordship and Justice Devashish Barua, and there were the division bench has modified the order of the single bench.
Okay, okay.
Direction by the single judge was to regularize from initial appointment of the petitioner. Then the division bench has directed to regularize from the day of the judgment.
Yes, yes, yes.
The horticulture regarding to the
Yes,
lordship.
yes. Learned Counsel for the petitioner, Mr. I. Jamil is present. He submits that he may be allowed to withdraw the petition. I won't say anything. Withdraw the petition. Stop. Accordingly, the petition is closed upon withdrawal.
Much.
Item number 10.
Closed and disposed of. Huh?
Please, Lordship.
Yes.
Lordship, I'm making a mention on behalf of Gauhati, who is representing for all the respondents here. My Lord,
Where is Gauhati? See, the SLPs which were relied upon, they have all been dismissed. Okay.
my Lord, if I may
And
be
the
allowed,
writ appeal also.
my Lord, if I may be
Writ
allowed,
appeal, it was defective.
Yes, my
And
Lord.
that has not been rectified.
Yes, my Lord, in connection to this, Your Lordship, just like my Lord has mentioned, read Appeal 28 of 2025, which has remained effective, so the same has been rectified, my Lord. So the appeal is under preparations. However, my Lord, there is some eligible annexures.
There is some.
Eligible annexures, so I may be allowed some
No,
more
but
time, my Lord.
in view of this SLPs, whether even filing the writ appeal, will it be admitted? It will not be admitted. It's just a wastage of time, isn't it? Because you are relying on these SLPs,
my lord.
whereas these have already been dismissed. So what ground do you have anymore? No more ground. Because this entire case was on the question of that domicile.
Domicile, mismatch of domicile.
My lord.
Yes.
My lord.
So you have no option but to comply. Anyway, if since Gauhati is not there, 1 week,
Then, my lord, 2 weeks then, my lord.
2 weeks.
My lord.
Lordship, not next week, Lordship.
Then, my lord.
Division bench is there tomorrow, day after also.
Exactly, my lord. Over, my lord, the writ appeal is still yet to file, my lord, because of those.
Oh, yet to
illegal-
file.
Yes, my lord.
So as of date, there is no pending writ
So
appeal.
as of now, there is nothing.
Yes.
Yes.
From our side, we are trying,
And
my
then
lord.
your affidavit which you have filed here also is now no more, it doesn't have any meaning now.
My lord.
Yes. Learned Counsel, Mr. A. Jamir appears for the petitioners.
And Lordship, on the next date, Gauhati may be, Learned Gauhati may be present.
Yes, yes. I don't know what he will say, but he has nothing to say.
Lordship.
Learned Counsel, Mr. C. Chingyang Pom, na?
Yes, ma'am.
Appearing for Mr. Gauhati, Learned CGC, submits that the respondents herein have rectified the writ appeal number 28 of 2025, and the same is going to be filed
My lord.
within 2 weeks. Stop. And therefore prays that the matter may be listed after 2 weeks. Stop. This court has observed that the respondents are relying on the SLP number 30 of 2024, 1195-1197/2025, and SLP civil number 12511/2025. So, however, the aforementioned SLPs have already been dismissed by the Honorable Supreme Court, and therefore the respondents are directed to appear. No, there is counsel for the respondent is directed to appear on the next date after 2 weeks, and file the compliance or receive further instructions on the matter. Okay, we'll see what he has to say.
My lord. Obliged.
Otherwise we'll have to call
Lordship,
them.
a date may be
Otherwise-
fixed.
Yes, after 2 weeks, give a date after 2 weeks.
15.
Okay, 15th, yeah, 15/6, huh?
My lord. Obliged.
Obliged.
For admission, item number 12.
May I please, my lady. My lady, this matter has come up for admission hearing today. However, my senior, Mr. A. Jimomi, he has some difficulties today. He's in court number 1. And then we have a
We come all
couple
over
of...
from Gauhati for this matter. So there was some endeavors to be made to dispose of this matter. We were under bona fide belief that matter will be, but he has some difficulty because there is one matter which is going in court number 1. Well, Lord, this matter, when the matter is taken up also, they should be clear on their stand, my lord. What I find after going through their affidavit, which has been filed, objection they have filed, they have taken a different stand altogether. And if we accept their stand, then, my lord, this petition has to be allowed, my lord. This is my respectful submission for this court, my lord. This is a matter regarding about, my lord, 415, 420 and 406 and 120B. There is an FIR which has been lodged by the informant against the petitioner and 2 others, my lord.
Acha, this is the case
Yeah,
where
these are
the
all protection.
respondent is abroad or something like
Yes,
that.
now he has come back, and my lord, as per direction of this honorable court, statement recorded, everything is done. And your lordship protected not to take any coercive measure. His statement also has been recorded. 94 notice your lordship has taken up, that also we complied. Then your lordship said no further they should not harass the petitioner by issuing another notice under 94. All is complied. Even in the last occasion, we got an order was passed by this court. The subject to the outcome, where charge sheet also is filed, that will be subject to the outcome of the petition. We are protected. There is absolutely no problem, my lord. But what I felt that if the matter is taken up, so it is good for everyone. Result, we don't know what will be the outcome of the result. But we are the similarly situated like informant, we are the investor only in this case. We are only an investor in this case also. To only safeguard, we become a director of the company. And because
And
your
then
lordship will...
there were some other connected petitions also which were separated.
Yes. Because my lord, because my case is totally on a different way. They are two botorias, they are promoters. We are neither a shareholder of this company. We are not a shareholders. But the only what I find in this case, my lord, what we projected, of course, it will take time. What I projected.
No, our senior is on legs in court number 1. That is the problem.
I know.
Just praying for a short date, my lady. Next week, 11th, they have also consented.
11th is Thursday, my lord. If your lordship is not inconvenient, that endeavor should be made to dispose of this matter, my lord.
I think
Yes, my lady. We will dispose it off next week.
What we don't know, but ultimately has to take a call.
Charge sheeted.
No, it's not charge
Not,
sheeted. That's right. Not charge sheeted. Not charge sheeted.
But all statements recorded, everything.
Oh, everything, my lord. Everything is recorded, my lord. All whatever direction was passed by this court, we complied. It is recorded. Everything is recorded, my lord. 94 also we complied. Not once, twice we complied, my lord.
11th then?
11th?
11th is okay. Learned Senior Counsel, Mr. D. Das.
Because I could have started, because my learned friend is not there. He is in court number 1, I think. Some matter is going
Maybe
on.
some hearing matter.
Hearing matter. I thought that I can start, then it can be part-heard by this court, my lord.
No, but we don't know, na?
Yes.
After this week, we don't know.
Oh, your
where-
lordship is not
Yes,
aware.
we don't know where
Again
we'll
will be fixed.
Because as per the roster, I'm here only till the 5th.
Okay.
Yes.
Otherwise, another problem will be there if it is
That's why
part-heard.
if we
Yes.
keep it part-heard.
Yes.
Learned Counsel, Senior Counsel, Mr. D. Das is present, assisted by Mr. I. Das. So, Ms. Lucinio, appearing for the respondent number 2, submits that the leading counsel, Mr. A. Jibomi, is on legs in court number 1, and therefore prays that the matter may be listed on 11th 11/6 for admission hearing. So, the prayer is not objected to by the learned counsel for the petitioner. So, accordingly, list on 11/6.
My lord, the endeavor will be made to dispose of.
Wherein an endeavor will be made to dispose of the matter.
Whether the CG is there, my learned, because
Mr.
he is there.
Learned
Yes, right.
PP, Mr. V. Jimumi is present. Yes.
PP is ready always.
Yes, he's always ready.
Right, madam.
For orders,
There are
item number
interim orders
Yeah,
which will continue.
the interim order to continue till the next.
I am deeply also.
Yes,
Yes, my
11 and
lady.
12 you filed.
For 11th, I filed. Yes.
Your Lordship,
Yes.
as per the contention of the respondent number 11, they've stated that it has been complied. However, that has not been implemented, Your Lordship. So if they come up with an appropriate affidavit detailing that they have been implemented and fixation has been done,
So
I think
I think my learned friend has misconstrued what we are saying. My lady, in compliance to the court's order, we have brought out the OM, that is at page 6.
Page 6 of the affidavit.
Yes. Page 6, this is the OM dated 18 February
Counting of
2020.
increment of
Ward
ward
judge.
judge employees upon regularization of service.
Yes.
In the matter of admission, the increments granted during work judge service shall be counted for fixation of pay subject to
And in the next
So,
page, we have written to the power department the methodology as to how to do.
How to
That
go
is at
about.
number 4. Yes. So now it is the duty of the power department to work it out. So my part, I had already complied in 2020.
Respondent 11 is
Finance Commissioner.
Finance Commission. Then what about respondent 9, 10 power department?
They are being represented by my learned colleague Imti Imson. But
So
I heard
as far
that
as respondent 11 is concerned, their part is over. Their role is over.
My lady, I've been informed that my learned colleague Imti Imson, he falls sick this morning. Yes,
Yes,
so
Your Lordship, after reaching the port,
What happened to him? Huh?
he suddenly falls sick and then he is under medical examination from our clinic here, which is there inside this High Court compound, Your Lordship.
So, my lady, if your lady pleases, then in respect of respondent number 11 may be closed.
Accordingly, the state respondents are directed to refix the pay and allowances of the petitioners at the time of the regularization by taking into account the increments already earned by them. Okay, so this is already complied, that
Yes.
refixing, that OM is already issued.
Yes.
Then after that, now it is the power department who has to do the fixation according to this OM.
Yes.
Okay, so we will now dispense with
Yes,
the
yes.
respondent number 11.
Since it has not been implemented yet, that's why I have.
No, that will be done by the power department,
Okay.
by the respondents 9, 10. Counsel for the petitioner. Miss T Chang, na?
Atsla keeps.
Oh no, Attila Gibbs. Okay, Attila Gibbs is present. Sitmu Chang is also in your chamber.
Yes, Your
Oh,
Lordship.
okay. Attila Gibbs is present. Stop. The learned counsel Ms. V. Shukri, appearing for the respondent number 11, has filed their affidavit. On 27/5/2026. Stop. By filing affidavit, the respondent number 11 / Finance Commissioner, Nagaland Kohima, has shown that the direction of this court has been complied with, in as much as the Finance Department has issued the OM dated 18th February 2020, by which it has been stated that the admissibility of increments granted to work charge employees in fixing their pay upon regularization of service shall be granted. No. I think we should just reproduce this whole thing, by issuing the office memorandum dated 18th February 2022, has stated as follows, and then you just reproduce this, page 6, annexure 2, an affidavit of respondent number 11. Then after that, the respondent 11 has further written to the Principal Secretary, Power Department, Nagaland, Kohima, by a letter dated 27 May 2020, directing, this is for what?
The methodology as to how they have to make the calculation.
Directing the Power Department and providing the instructions as to how the matter of calculation of increment has to be done. Stop. Then this, what is this annexure for?
Again, we reminded them
Okay.
to take up the,
Write another letter dated 13 March 2026. The respondent number 11 has again issued another reminder to the Commissioner and Secretary Power Department to follow up, to take up the follow-up action in accordance with the OM dated, that earlier one, no? OM dated 18 February 2020, and to fix the pay of the work charge employees upon regularization. Stop. She has therefore submitted that the order of this court has already been complied with by the respondent number 11, and praised that the matter may be closed as far as respondent number 11 is concerned. Stop. Para. This court has considered the submission of the learned counsel and has also perused the pleadings, specifically the affidavit of the respondent number 11. Stop. The direction of this court in WPC
237 of 2018.
of 18 was to refix the pay and allowances of the petitioners at the time of the regularization by taking into account the increments already earned by them during the work charge service as per the ROP Rules 1993, and thereafter to refix their later pays. Stop. This court finds that the respondent number 1 has already complied with the direction of this court.
11th.
Respondent number 11 has already complied with the direction of this court, and accordingly, the matter stands closed as far as respondent number 11 is concerned. Stop. Para. It is submitted that Mr. Im Tim Song is appearing for the respondent number.
For the power,
Respondent number 9, 10, 12. 9, 10, and 12. However, the learned counsel is indisposed today, and accordingly, it is prayed that the matter may be listed after 3 weeks.
Okay.
After 3 weeks. Stop. It is found that the respondents number 9, 10, and 12. Is it 9, 10, and 12?
Yes, 9, 10.
9, 10, and 12 have to show their compliance in response to the OM issued by the Finance Department. So accordingly, this is the matter after 3 weeks.
Obliged.
much obliged.
From the supplementary course list for admission, item number 23.
Your Lordship, I was just contacted by the counsel for the petitioner Muajamir that they are on their way, my lord. So this matter can be taken up after some time, my lord.
On the way.
Yes.
Or tomorrow? Should we take it up tomorrow? Is this for admission hearing?
Yes, Lordship.
So it will take time, no?
I don't know, but
It will
it's a short matter actually. Their application for filing the WS has been rejected by both the Civil Judge Senior Division as well as the District Judge. Against that, they have come that at least we should have been allowed to file WS. So far as we are concerned, we have no objection because it will be important.
Interest of justice,
Yes.
it should be filed actually.
Lordship. Meantime, we can wait for some time because order matters are also there.
Because we are going to the new High Court site, so I don't want to sit at
Then
2.
let it be tomorrow.
pass over, okay? Pass over for the day, on the, with the consent of the parties.
Obliged, Lord.
May I please, Your Lordship? Lordship, I beg to I'm for respondent number 4. And Lordship, I have instruction to appear for respondent number 5 also. And I have filed my vakalat, Lordship.
What about 2, 3?
Your Ladyship, I may be.
2, 3. Okay. And 1 is Enangam. So are you complying? All the respondents are now represented.
Lordship,
So you have to.
Lordship will be filing our affidavit, Lordship. I'll be filing on behalf of respondent number 4 and 5.
Regularization.
Yes.
Learned Counsel Ms. Atsela keeps present for the petitioner. Mr. N. Nangami is present for the respondent number 1. So Mr. V. Jimomi submits that he is appearing for respondent number 4, and he has also received instructions to appear on behalf of respondent number 5. And the vakalat nama has been filed.
Lordship.
He prays for how much time?
3 weeks time.
3 weeks time to file the complaints affidavit. So Mr. Moy Imchen appears for the respondent number 2 and 3. You'll also file?
Yes.
And he also prays for, and he has also made a similar prayer. What about R1?
No, Your Lordship. Steps has to be taken by the others.
Okay. Accordingly, list the matter after 3 weeks.
From the supplementary copies, item number 23.
My apologies, Lord.
Yes.
Some facility being missed.
Actually, we have passed it over. Pass over for the day. Because
May kindly accommodate
it may take some time, na? It will take time.
Just 2 orders.
Okay.
The issue is very
Let's see.
simple, Lordship.
Okay. Let's see.
My prayer is very limited to filing of written statement. Because on the day when I entered appearance, I made a prayer for filing a written statement, which was rejected.
Why was it rejected?
It was rejected on the ground that I have approached the court of a
Late.
considerable period of time. Yeah, there was a delay of few years. Lordship, this is an exceptional case. I'll be referring to some documents as well as some judgments. The brief facts, Lordship. There's a suit which was filed in the year 2008, which is numbered as declarative suit number 1 of 2008. Declarative suit 1 of 2008. So altogether, there are 7 defendants. 7 defendants in the case. I was implemented as the defendant number 1. Defendant number 1 as Onopu Village Council. Onopu Village Council. Now, defendant number 2 and the rest of the other defendants, they have also filed a written statement. But if for knowledge of this honorable court, the date of filing the written statement is also very important, because defendant number 2, they filed a written statement in the month of March 2012.
Defendant 2 filed in
In the month of March 2012.
March 2012.
Which was after a period of 4 years after instituting the suit. March 2012. And the rest of the defendants, that is defendant number 3, 4, 5 and 7. 3, 4, 5 and 7, they have also filed their written statement in the month of February 2016. February 2016. Yes. That was after a period of more than 8 years. More than 8 years they have filed a written statement. Now an order, the impugn order was passed on 20 March 2020. 20 March 2020.
20 March
2020.
2020.
So that was the day the Learned Trial Court was passed an order on the preliminary objection which was raised by the other defendants, except the defendant number 1, because I have entered appearance only on that day. And on 20 March 2020, the Learned Trial Court passed an order on the maintainability of the suit.
So that was
Okay,
at its initial stage, in the preliminary stage.
And you also entered appearance on 23/2020.
Yes, on the same day when the order was passed. And the question of maintainability was also rejected, along with the defendant number one. When I entered appearance, I made a prayer for filing a written statement. Both the prayers were rejected. Of course, the preliminary hearing was taken place prior to that,
Earlier,
but the order was passed on the same day. And on which day I have entered my appearance, I have also expressed my difficulty why I could not approach the Learned Trial Court on time. There was a specific submission before the Learned Trial Court that due to change of the village council, and that was the latest village council who has engaged, who took a decision to contest the case. I have made a specific prayer, and even that was also recorded. My submission was also recorded in the impugned order. If I may be allowed to take your lordship to the impugned order, page number 269. I'll read only the relevant portion of the order. 269. The lordship will find the relevant portion of the order 275. This is dated 20 March 2020.
Starts from?
The relevant portion starts from 275, the last three paragraphs. Because the entire order discussed about the maintainability, which was rejected. From the third paragraph, may I read it? It is prayed by the learned counsel for the defendant number one for time to file his written statement. It is the submission of the defendant that the village council chairman has recently been changed, and therefore they require time to file a written statement. On perusal of the CR and as per the submission of the learned counsel for defendant number one, it appears that since filing of the suit, no written statement has been tendered by the defendant number one till date. As such, given the time that has been passed and the ample opportunity already given to the defendant, this court cannot accept this prayer. Defendant number one may, however, only cross-examine on the point of law. That was the order passed. Fixing 30th of April 2020 for framing of issues, that was the order. Now, being aggrieved by this, I have filed an appeal, which was numbered as civil appeal number 1 of 2020, before the district judge Mohokchong. Now, before coming to the appeal, outcome of the appeal, if I may be allowed to refer to three documents. The first two documents will be on the approval of the newly selected or elected village council members, and the third document will be the resolution which was adopted by the newly elected village council members to contest the case. So approval, the first approval 259, page number 259. 259. This is the approval issued by the Office of the Deputy Commissioner Mohokchong to the administrative officers of different blocks. Approval of newly elected selected village council members of 82 villages, that is the subject under Mohokchong district. Approval of newly elected or selected village council members of 82 village under Mohokchong district. This is dated 30th of November 2018. Now, on receipt of this approval letter from the Deputy Commissioner, the ESC Longchem has also passed this 269, page 269. This is a letter dated 8 February 2019. 261. Page number 261. 261. So this is a letter addressed to the chairman of Aonupo Village Council. Approval of newly elected selected village council members. This is dated 8 February 2019. So these are very important notes. Now, my village, what you will find in the next page, 262, serial number 40, Aonupo village. So these are the names of the village council, newly elected or selected village council members of Aonupo village.
Serial number 40.
Yes, serial number 40. Now, pursuant to this, after constituting the new village council, a team of village council, the village council of the Ryong Sangar Putumandan of Onopo village, they adopted a resolution.
No, but before that also the old village council
I'll
was
come to
there.
that. Yes, I'll come to that. Now, in this resolution, they have also discussed the circumstances why they did not approach or why they could not take a decision to contest the case. Page number 265, the resolution which was adopted on 5th 11 2019. 5th 11 2019. Type copy, Lodge will find it, page number 267. And this document is very important for defining the present case. May I read it, Lord?
Yes.
The Onopo Village Council, on being aware of the case filed by Mangkutongban Nongkamer clan, a sub-clan of Onopo village before the civil judge, Junior Division Maoktong, wherein the Onopo Village Council was impleaded as respondent number 1 in declaratory suit number 1 of 2008, held numerous meetings including deliberations with village elders, and in the process considerable time had elapsed and no positive action could be ensued on time. Moreover, this is important, Mr. Takatamchan, ex-chairman of Onopo Village Council, did not adhere to expedite the matter to contest the case before the court and deliberately delayed the process. Now the reasons. Besides that, a declaration was made by the chairman in connivance with the Mangkutongban Longkamer sub-clan to the extent that Shri so-and-so and so-and-so participated in the establishment of Onopo village, without the knowledge of the village general body, which led to turbulence and chaos in the village administration. Consequently, the Onopo Village Council was dissolved in the year 2017 after prolonged tussle. As a result, several seasonal chairmen took over the village council for an interim period. Finally, a public general meeting, Sangsama, constituted a nominating committee to nominate or select a new team of the village council members, and the said team was forwarded to the government for approval. The ESC Longchem Nagaland White letter dated so-and-so has conveyed common approval of newly elected or selected village council members to the chairman Onopo Village Council. Subsequently, after several meetings, a decision is taken today by the Onopo Village Council under the chairmanship of Sri so-and-so to contest the case and to engage Mr. so-and-so to represent Onopo Village Council as defendant number 1 in declaratory suit number 1 of 2008, and also to take all necessary legal steps before the Learned Civil Judge, Junior Division Maoktong. So it was only on this day, 5th of 11 2019, a unanimous decision was taken by the village council as well as the Ryong Sangar Putumandan to contest the case. It was on the 5th of November 2019. And the next date of listing before the London Trial Court was only on 20th of March 2020, on which day the impugn order was passed. So that was the earliest opportunity for the defendant number 1 to enter appearance and contest the case.
Okay.
And
then, in appeal, what did the court say?
And appeal, 293, page number 293. The appeal was disposed on 18th of September 2025. It's a short order, if I may be allowed to read the entire order.
Yes.
Page 293.
This is dated 18/9/2025.
2025.
Yes.
In the fact of the present case, a declaratory suit. May I read it on?
Yes, please read.
In the fact of the present case, the declaratory suit number 1 of 8 was filed by the appellant plaintiff on so-and-so. And out of the 7 defendants in the suit, only defendants 2, 3, 4, 5, and 7 filed their respective written statements. However, it was only on 20th of March 2020 during the hearing of the preliminary objections that the appellant defendant number 1 made appearance and sought time to file a written statement. The Learned Civil Judge, Senior Division Maoktong, by its order dated 20th of March 2020, rejected the same on the ground of delay, and that ample opportunity is already provided. Hence, the instant appeal to set aside and quash the impugn order dated so-and-so passed by the Learned Trial Court to direct the trial court to allow the appellant, defendant number 1, to file its written statement in declaratory suit number 1 of 8 and to state the proceedings of suit number 1 of 2008 in the interior. Both the learned counsels, Mr. So-and-so and Mr. So-and-so for the respondent are heard at length, and also on perused, the citation relied upon along with the gist of the written arguments as filed by both the parties, the same on report and are not reproduced in the order for the sake of brevity. 3. The CPC 1908 provides the limitation period of filing the written statement within 30 days, but not later than 90 days. However, in this instant case, there appears to have a delay of more than 12 years, where the appellant, defendant number 1, approached the Learned Civil Judge, Senior Division Mokchong, seeking time to file the written statement. The appellant, defendant number 1, primary argument for the delay in filing the written statement is that the present appellant's village council was elected only in the year 2019 and was kept in dark so as to the proceedings of the civil suit before the Learned Civil Judge, Senior Division Mokchong, by its predecessors for the reasons that the summons served upon the appellant, defendant 1, at that relevant point of time was not made known to the citizens, and as such, there was no occasion to adopt resolution by the Sangsama, that is the village general body of Onupo village to contest the case. 4. That what could be gathered from the case record is that appellant defendant 1 appeared in court on 22nd of January 16 in connection with the suit. The appellant defendant 1 had even filed an application before the civil judge Senior Division Mokchong, praying for grant of opportunity in time for settlement of the suit outside the court. The said application is dated 24/2017, signed and sealed by the appellant defendant 1, who was the former village chairman of Onupo. The receipt of summons by the appellant defendant 1 are also on record. Apparently, the appellant did not engage a counsel till 20 March 2020, though the suit was proceeding since 7/11/2008. Now, only after a delay of more than 12 years, the appellant defendant 1 had thought it fit to file the written statement before the Learned Civil Judge and was rightly rejected by Learned Trial Court, citing its reason. If there was a delay in filing the written statement within the statutory period, it was beholden upon the appellant to file an application to the concerned court for continuation of delay, providing valid reasons for the delay. However, instead of filing continuation application, the appellant chose to seek time to file a written statement and the resultant rejection. It has to be stated herein that a village council is a statutory body represented by the chairman. When there is a change of guard, the new incumbent is a legal successor to the predecessor, and assumes the function, assets, responsibilities, obligations, and liabilities. The statutory body cannot escape liability just by claiming its new entity. Thus, when the appellant defendant 1 was a party to the case and was making appearance in court, and subsequently when the present village council members were selected, there is a deemed legal continuity of statutory body, the village council. Even if this court is persuaded to believe that the appellant was precluded from filing a written statement since the former village council had taken no decision to contest the case, since the same does not absolve the appellant of his legal obligations under the established laws of the land. If such contentions are allowed, it will lead to absurd situation, making laws redundant. The Civil Procedure Code is a statutory provision which governs the procedural aspects of civil litigation, which is consistent with justice and equity. To set it north, such provisions without any exceptional circumstances, genuine grounds or legal basis will amount to negating the very purpose for which it has been set. In the present case, this court is of the view that the appellant had shown intentions of ignorance relating to ongoing proceedings in the suit and the continuity and the representative character of the statutory body which he holds. The delay in unreasonable and justification of the same is not convincing. In the declarative suit, the respondent had only challenged the validity of decisions later so passed by the defendant number 2, and had also assailed the omission of the same long-term in Onupo Village Council centenary no that is stood in the year 2006, which was edited and published by defendant 6 and 7. Thus, apparently no relief has been sought against defendant number 1. The naming of the appellant defendant 1 in the suit appears to be a formal character representative. The village council, it is worthwhile to reflect that even with the right to file a written statement closed, the appellant can still participate in the case by cross-examining the respondent, witnesses, and making arguments based on the existing record. In view of what has been discussed above, this court does not find itself impelled to interfere with the impugned order dated so-and-so, passed by so-and-so. This court does not find merit in the instant appeal. Accordingly, the civil appeal 1 stands dismissed. The stay order granted so-and-so stands vacated. As a sequel, the suit is restored for trial on its merit. Now, against this order, the instant petition was filed, and this honorable court by an order dated 23rd of October 2025.
So basically, the appellate court said that the respondent one, that is the present petitioner, is not a necessary party.
Yes.
Even without
Yes.
the respondent one, it can proceed. That's what the court meant to say.
Yes.
But what do you say? Is the village council a necessary party?
Very much, very much.
If the respondents had only challenged that order dated 19/10/2007.
Because the prayer of the plaintiff in the trial is very specific, and the first prayer is declaration of clan status as honorable village founters. Now, when they want a declaration of as a village founder, the village council, being the only statutory body in a village, is very much a necessary party in the suit. And not only examining, cross-examining, I have to file a written statement, I have to bring on record the genesis of how the village was established. In fact, other defendants 6 and 7, it is a body or a committee constituted by the church. And it was temporary in nature, just to publish that souvenir for that purpose. And of course, they have filed a written statement. But village council, as your lordship knows very well, the village council is very much a necessary party when it comes to the genesis of how the village was established. Which is why I have brought on record all the documents before the learned appellate court also.
So in that case, that usually quoted phrase that procedure cannot stand in the way of justice. So that should have been taken, because if village council is a necessary party, in spite of the delay, if the case cannot be validly adjudicated without the stand of the village council, then in that case it is required, isn't it?
Yes. And I have also included the resolution which was adopted. And by the resolution, the circumstances were explained in the resolution in a detailed and comprehensive manner.
Do you have any judgments regarding this procedural?
Yes, I have judgments. And even on exceptional circumstances, because I detected as an exceptional circumstance, why I could not.
No, that also,
contest.
and then if the cause of justice is affected, then procedure has to take a back seat.
First, if I may be allowed to rely on the decision of 2005 for SSC 480. This being on the question of Order 8 Rule 1 not being mandatory, it is directory in nature. Paragraph number 41, the relevant paragraph 41.
Paragraph 41.
Paragraph 41 starts from paragraph 41. Kailash case, paragraph 41 starts from paragraph 41. May I read it? Considering the object in the purpose behind enacting Rule 1 of Order 8 in the present form and the context in which the provision is placed, we are of the opinion that the provision has to be construed as directory and not mandatory. In exceptional situations, the court may extend the time for filing written statement though the period of 30 days and 90 days referred to in the provision has expired. However, we may not be misunderstood as nullifying the entire force and impact, the entire law and vigor of the provision. The delaying tactics adopted by the defendants in law courts are not prohibited as they do not stand to gain by delay. This is more so in election disputes because of delaying the trial of election petition. The successful candidate may succeed in enjoying the substantial part, if not in its entirety, and it's not an election process and it's not an election petition. Now, paragraph 42. Paragraph 42. Ordinarily, the time scheduled prescribed by Order 8, Rule 1 has to be honored. The defendant should be vigilant. No sooner the writ of summons is served on him, he should take steps for drafting his defense and filing the written statement on the appointed date of hearing without waiting for the arrival of the date appointed in the summons for his appearance at the court. The extension of time sought for by the defendant from the court where whether within 30 days or 90 days, as the case may be, should not be granted just as a matter of routine and merely for asking more so when the period of 90 days has expired. The extension can be only by way of an exception and for reasons assigned by the defendant and also recorded in writing by the court to its satisfaction. It must be spelled out that a departure from the time schedule prescribed by Order 8, Rule 1 of the court was being allowed to be made because the circumstances were exceptional, occasioned by reasons beyond the control of the defendant, and such extension was required in the interest of justice, and grave injustice would be occasioned if the time was not extended. This is exactly the case, my case. Paragraph 44. The extension of time shall be only by way of exception and for reasons to be recorded in writing, however brief they may be by the court. In no case shall the defendant be permitted to seek extension of time when the court is satisfied that there is a case of laxity or gross negligence on the part of defendant. The court may impose cost for dual purpose. 1. To deter the defendant from seeking any extension of time just for the asking, and to compensate the plaintiff for the delay and inconvenience caused to him. So at the most, a cost can be imposed, but not rejecting my prayer because I have satisfied because I have circumstances which satisfies the court. 46. We sum up and briefly state our conclusion as under. 46. The trial of an election petition commenced from the date of receipt so and so. This is with regard to the election petition. Now Roman 4 is 4 and 5. Under paragraph 46, Roman 4. Purpose of providing the time schedule for filing the written statement under Order 8, Rule 1 is to expedite and not to scuttle the hearing. To expedite. The provision spells out at this ability to the defendant. It does not impose an embargo on the power of the court to extend the time. Though the language of the provision to Rule 1, Order 8 is caught in negative form, it does not specify any penal consequences flowing from the non-compliance. The provision being in the domain of the procedural law, it has to be held discretionary and not mandatory. The power of the court to extend time for filing written statement beyond the time scheduled provided by Order 8, Rule 1 is completely taken. It's not completely taken away. Next citation list. 2008-11 SCC 769. Paragraph 15. May I read paragraph 15?
Yes.
Therefore, following the principles laid out in the decision, as noted here and above, it would be open to the court to permit the appellant to file his written statement if exceptional circumstances have been made out. It cannot also be forgotten that in an adversarial system, no party should ordinarily be denied the opportunity of participating in the process of justice dispensation. Therefore, unless compelled by express and specific language of the statute, the provisions of Order 8, Rule 1 CPC or any procedural enactment should not be construed in a manner which would leave the court helpless to meet extraordinary situations in the hands of justice. Next is 1999, 8 SCC 396. Paragraph 29. Paragraph 29 may very good.
Yes.
As pointed out earlier, the court has not to act blindly upon the admission of a fact made by the defendant in a written statement, nor should the court proceed to pass judgment blindly merely because a written statement has not been filed by the defendant traversing the facts set out by the plaintiff in the plaint filed in the court. In a case specifically where a written statement has not been filed by the defendant, the court should be a little cautious in proceeding under Order 8, Rule 10 CPC. Before passing the judgment against the defendant, it must see to it that even if the facts set out in the plaint are treated to have been admitted, a judgment could possibly be passed in favor of the plaintiff without requiring him to prove any fact mentioned in the plaint. It is a matter of court's dissatisfaction, and therefore only on being satisfied that there is no fact which need to be proved on account of deemed admission, the court can conveniently pass a judgment against the defendant who has not filed a written statement. But if the plaint itself indicates that there are disputed questions of fact involved in the case regarding which two different versions are set out in the plaint itself, it would not be safe for a court to pass a judgment without requiring the plaintiff to prove the facts or settle the factual controversy. Such a case would be covered by the expression the court may, in its discretion, require any such fact to prove under sub-rule 2 of Rule 5 of Order 8, or the expression may make such order in relation to the suit as it thinks fit, used in Order 10 of Rule or Order 8. Now, the other defendants, they have filed a written statement. Now they have raised disputed question of facts. Even the committee, for that centenary, for coming up with a souvenir, even the committee has also raised disputed question of facts. Now the written statement of the defendant number 1 is very much required, very much necessary for proper adjudication of the case. Now the last citation is 2022 SEC Online SC 613. It's a one-page order which was passed on 9th May 2022. Paragraph 4. Just a short paragraph. May I read it from the paragraph 2?
Yes.
The challenge in the present appeal is to an order passed by High Court on so and so where delay of 193 days in filing the written statement was not condoned. Admittedly, the suit for injunction filed by the plaintiff is not the one which is governed by the commercial court. Therefore, the time limit for filing the written statement under so and so is not mandatory in view of the judgment of this court reported in so and so, which I have relied upon. 4. In view of the aforesaid judgment, we find that the delay in filing of the written statement could very well be compensated with cost, but denying the benefit of filing the written statement is unreasonable. Consequently, we allow the present appeal. The order passed by the High Court is set aside. The written statement already filed is taken on record.
Okay.
Therefore, relying on all this judicial pronouncements of the Honorable Apex Court, it is my respectful submission that it is an exceptional case. Relying on the
Let us see your prayer once.
prayer in the present, page 21.
So she said the impugn order, dated such and such, declarative suit, such and such. So, it would be, in case this is disposed of, it has to be remanded back to the civil judge,
Yes.
senior division.
Yes. Your Lordship, I kindly appreciate it is still in nascent stage. Issues are yet to be framed. Even after
Issues
12
not yet
years.
framed.
Yes.
Okay. Yes,
I am for respondent number 2, Lordship.
I think there should not be much objection.
No. So far as that part is
Because
concerned, but
proper adjudication can be done only on the basis of the
Yes.
village council's written statement.
during the course of submission, my learned friend has referred about filing of WAs by respondent number 2. in 2012, although the suit was instituted only in 2008. Lordship is well aware about the life of a trial of a civil suit. During the preliminary stage, even for temporary injunction, it moves like a shuttlecock from lower court to high court, high court to lower court.
Years, even for the
Twice. During the intervening period, we had to approach the Honorable Court on 2 occasions, like that. That is how the matter got delayed. So I remember one classical joke on the civil trial. The father was a lawyer, and then he was getting on years, becoming old, so he is unable to carry forward with his practice. So his son was also studying law and then finished law. So he was very excited that his son has become a lawyer, so that his son will inherit his profession. So at that relevant point of time, the father handed over 5 cases to his son. My son, now that you have joined the profession, I am very happy. Please look after these 5 cases. I believe this will be good enough for your start in the profession. After 6 months, father wants to review the performance of his son. So after 6 months, he called his son one fine day, and his son was so excited that he wants to show his performance and progress. Daddy, I could dispose of all the 5 cases. And then father gave him a slap. Instead of appreciating his performance, father has given a slap. You are not fit to be in this profession. These are the 5 cases. How I have given your education, I have supported the family all along.
With these 5 cases.
With these 5 cases. But you have finished it within 6 months. So you are not fit to be in this profession. I just recollect, considering the delay caused in this proceeding, there was reasons. Secondly, Lordship is well aware about the administration in the village. Aunokphu village is a small village. It consists of 80 to 90, if not improved now, approximately 80 to 90 households. Very small village. Now, in a village, there are lots of intermarriages. My Chamir clan will marry Longomer clan, Longomer will marry Bongonra clan. That way they are connected, interconnected.
They are all related.
Very difficult to keep a rolling also at times. And at home, even if we shout in the street like anything, at home we are under a woman. So the saying goes, behind every successful man, there is a woman behind. We fully agree that. So we are mostly under women when we go home. So like that, it's very difficult to take a decision even in the village council. The reason best known.
Yes.
So likewise, there was unfortunate situation in the Aunokphu village.
So previous council chairman, maybe he was not too keen.
I'm not saying anything on that, but
maybe.
apparently those are the reasons which cannot be expressed also.
Yes.
So those are the reasons, number 1. Number 2, say for administration of the village, even under the Nagaland Village Council Act, under section 14, how to administer the village is invested with the village council. Command and control, everything. Now, I'm respondent number 2. This is in social organization only, social body. Sinso Mungtang means it will consist of the entire citizens of the village and the persons who are migrated from the village and residing elsewhere. For example, Kohima, Dimapur, Mugokchong, they will also be part of the Sinso Mungtang. So I belong to that organ. Whereas that is only a customary body, I should say. Whereas village council is a statutory body, constituted by a statute, and they are governed by the statute. For example, now, in connection with this matter, because the real issue emerged out of the foundation of the village. In the souvenir, they have mentioned that so and so should not happen there because our village migrated from Moromong village, consisting of this and that clan. They were not there in the initial foundation. So it was not included. But Mangutongo Longkomer wants to include, no, we should also be included in the founding members. In that connection, in an issue of such nature, what will do? Warmong village for tomorrow, suppose, they wanted to come to Onukhu village to have a discussion on this issue. They cannot secretly come and sit with some individual or a particular club. No. Village council.
They have to come to the village
Yes,
council.
through proper channel. So it is a village council. So I think.
What about respondent one? Respondent one is not.
Respondent number one is the present petitioner. Village council.
No. This Mangko Tongman Longkamer clan.
They are plaintiff.
The plaintiffs are not here.
No, they are not here.
They are not here.
Notice was served.
Yes.
I am
Team
respondent.
served.
As well as Dusty Service.
Okay.
We have also filed an affidavit
And
to that.
team serve order is there
Yes.
by this court.
Yes.
Okay. So they chose not to appear.
Yes, even after that, two opportunities were given.
Okay.
So the village council will be a necessary party
Then in
for
that
proper
case, we will
adjudication.
remand it back to the civil judge senior division and give a direction to allow the village council to file their written statement.
So that trial will
And
proceed.
then give a specific
Progress.
date because you should not delay any further.
Yes.
Correct, Lordship.
Heard any counsel for the petitioner, Mr. Moy Jamir. So also heard senior counsel, Mr. Sidi Jamir, assisted by Impong Jamir for the respondent number 2. Don't say order reserved, dispose. I'll dispose it in the chamber.
Lordship.
Item number 16.
May I please, Lordship, Your Lordship, this IA is filed for implement of the new respondent. 15.
Item 16. Item 16. What about 15? You did not call out 15.
15 is not called out.
15.
Yes.
Is adjourned. Mentioned.
I suppose there is an IA, item number 15.
In item 15, is there a connected IA? No. There is no connected IA.
I might have made a
You
mistake.
check it
I'm
up.
sorry.
Yes.
My apologies.
Yes, item 16.
Yes, my lord. May I please, Lordship. As directed by Honorable Court, I filed my affidavit on compliance affidavit on 19 May 2025 or 26, my lord.
Oh, regarding the service.
Yes, my lord. And Your Lordship, may kindly see the page 4, Annexure A. This is the acknowledgement message from the
Delivery such and such
Enforce, yes.
successful.
the last paragraph.
Yes.
It clearly mentioned that
On
number so and so
25
is
for-
successful on 2026,
25
my
for
lord.
2026.
Yes.
Learned PP, Mr. E. Tipapong is present. So the Learned PP has filed the complaints affidavit regarding notice on the respondent. Sole respondent, huh?
Yes, my lord.
Notice on the respondent. Stop. The tracking records shows that the service has been affected on the respondent by successful delivery of the consignment on 25/4/2026. So the notice on the respondent is therefore deemed to be served. Stop. However, none appears for the respondent when the matter is called today. Okay, we will hear you then.
My
What is
lord-
it about?
Yes, my lord. Your lordship may kindly see my IA number 47 of 2025. My lord, this IA was filed during the pendency of criminal petition number 1 of 2025. And my lord, your lordship may kindly see my paragraph number 2. My lord, the brief facts of the case is that respondent has filed anticipatory bail 5 of 2025, and this honorable court has allowed the respondent to go for anticipatory bail, and given direction to appear before the IO, and he appeared, my lord. And thereafter, during the pendency, the respondent has filed criminal petition number 1 of 2025, and during the pendency of that criminal petition, the IO of the case has issued notice to the respondent to appear in person, my lord. Your lordship may kindly see para 2.
Yes.
Para 2 of my IA, my lord. May I read, my lord, this paragraph? That thereafter the respondent accused has filed criminal petition which was numbered as criminal petition number 1 of 2025, praying for quashing of FIR dated 21/11/2024 in connection to so and so. However, the criminal petition is still pending because this line I've written when this IA was filed during the pendency of criminal petition.
So the criminal petition is
Is
still pending?
yes, already dismissed, my lord.
Disposed? Oh, dismissed.
Yes, my lord.
Okay.
By order dated 10/2/2026.
1
my lord.
minute. Criminal petition 1 of 2025 dismissed on
10/02/2026.
10 to 2025.
26.
Oh, 26.
Yes. During the pendency of the criminal petition, the investigating officer had issued notice to the accused respondent to appear physically for further interrogation on 02/6/2025, 23/6/2025, and 21/7/2025. However, despite of clear direction, the respondent had failed to appear. Thereby, the investigation officer has forwarded a letter to the applicant, public prosecutor, to apprise before the honorable court for cancellation of anticipatory bail granted to the accused on the ground that the accused has willfully and deliberately disobeying and misusing the liberty granted by the honorable court. It is pertinent to mention herein that for the interest of justice, the honorable court was so gracious enough to the respondent and afforded sufficient opportunity to appear before the investigation officer by passing its multiple order dated 29/8/2025, 23/9/2025, 13/10/2025, and 23/10/2025. However, the accused respondent has taken charge for granted and did not comply as stated by the honorable court. Moreover, on several occasions, the accused has made an excuse of health problem due to which he was unable to appear before the investigating agency. In compliance of the honorable court order, the investigation officer has submitted its several status report dated 21/9/2026, 25, 12/10/2025, 10/10, 18/10/2025, and 07/12/2025 before the honorable court, apprising that the accused is not cooperating the investigation agency and prays for cancellation of liberty granted by the honorable court dated 11/2/2025 and 28/2/2025 in anticipatory bail 5 of 2025. Your lordship may kindly see the last order, that is page number 17, 18, 19. These are the notice sent by the investigating officer to the respondent, madam.
No, this is during the pendency of the
Yes.
pre-arrest bail, isn't it?
Yes, my lord. And my lord, no. After
After the
yes,
anticipatory bail was
yes,
disposed.
yes, my lord. And the last, your lordship may kindly see the page 25.
this Honorable Court has noted
Page,
page 25, Annexure C, first order dated 08/12/2025. This is the last order passed by the Honorable Court, my lord. In the para 2, it clearly mentions that opportunity has been given to the accused, the respondent. May I read this paragraph, my lord? From the last order passed by this court, dated 24/11/2025, the petitioner was again directed to appear before the investigating officer physically on 3/12/2025 at 1 p.m. It is informed by the learned PP that he has not complied with the order of this court, and it is also submitted that in the last order it has been reflected that order dated 29/8/2025, 23/9/2025, 13/10/2025, and 23/10/2025, the petitioner was directed to appear before the investigation officer, but he failed to do so. In non-compliance of this Honorable Court, it is submitted by Mr. So-and-so that the petitioner is suffering from melena, and because of treatment of his ailment, he could not appear physically before the investigating officer. However, he is ready to extend his cooperation with the investigating officer. And my lord, the last paragraph, considering all these aspects of the case, it let this case be listed immediately after the reappointing date with the direction to both parties to proceed with the hearing. In view of the order dated 24/11/2025, a cost of rupees 10,000 is imposed on the petitioner, which would be paid to the respondent to complainant. This order has not been complied, my lord.
this order also
Not complied. My lord, here for several on notice was attempted to serve to the respondent.
Investigation is still going on.
Yes.
Investigation is still on.
Now he is not receiving the call. Yes. And your lordship has seen that that annexure that which I have closed the acknowledgement message. Here he has received on 25/4/2026. After that, the case was listed twice. And even then, despite of receiving the notice, he is not cooperating, my lord. So my humble submission is the respondent is willfully disobeying the order direction by this Honorable Court and the notice issued by the investigating officer. So that anticipated bail granted to the respondent should be cancelled, my lord, for the interest of justice. That is my humble submission, my lord.
Do you have any case laws
My lord, I have,
support regarding cancellation of pre-arrest bail?
now I don't have, my lord. Yes.
Okay. You supply later if you can find, okay?
Yes.
What did I say? Continuation of that last order, but none appears for the respondent now in the matter scope. Stop. Para. The learned public prosecutor, Mr. T.E. Tibakom, is heard on the instant application. Stop. The present application has been filed under Section 483, Clause 3 BNSS, praying for cancellation of the anticipatory bail order dated 11/2/2025 and 28/2/2025, passed in the anticipatory bail application number 5 of 2025. No, wait, I was just thinking whether this application is maintainable, whether an appeal should have been filed instead. Just give me BNSS. Disciplinary number 5 of 2025. No? Stop. Para. The facts leading to the filing of the instant application is that the accused slash respondent had filed an anticipatory bail application number 5 of 25 before this court. And by the order dated 11/2/2025, this court had granted pre-arrest bail to the respondent accused on the condition that the petitioner shall appear before the IO of the Dipupar PS Dimapur on or before 25/2/2025, and that the petitioner slash accused shall not tamper with the evidence of the investigating agency or the prosecution witness. No, that was interim pre-arrest bail.
interim
You say interim pre-arrest bail. No, was granted interim pre-arrest bail. Thereafter, the matter was listed on 28/2/2025 for final hearing.
Yes, ma'am.
Stop. On 28/2/2025, when the matter was finally heard, this court was of the view that the custodial interrogation of the accused slash respondent was not required at that stage, and therefore the interim bail granted, a pre-arrest interim bail granted on 11/2/2025 was made absolute, and the anticipatory bail application 5 of 2025 was disposed of. Stop. Thereafter, where were the notices sent after this dates? Thereafter,
It is stated in paragraph 2, madam.
no, in your annexure,
Annexure,
after the petition was disposed of, you were saying that you had summoned
yes,
him, isn't it?
17, page 17, 18, 19, 20,
No,
21.
page 17 is the letter to you.
No, yes, from 18. 18.
Thereafter, by a notice under section 35(3) BNSS, the respondent slash accused was directed to appear before the investigating agency on 15/6/2025. In order to continue with the investigation. However, the respondent slash accused did not appear. Stop. Another notice was sent to the respondent slash accused on 23.
Yes, 23,
On
6,
23/6/2025. Stop. However, the petitioner still did not appear before the investigating agency. Stop. Subsequently, three more.
Yes, 20.
3 more notices were issued. No, wait.
3.
Subsequently, several notices were again issued to the respondent slash accused on 2/7/2020.
21/7.
21/7, 2025, comma,
9.
21/9, 2025, comma, 12/10, 2025.
My lord, this letter is the status report submitted by the
Sorry,
IRS.
sorry, okay. Till 21/7 only, na?
Yes, ma'am.
21/7, 2025. And what was the last notice? That was the last notice.
Yes, my lord.
The last one you say and, na? Put and 21/7, 2025. Stop. In spite of several notices issued, the respondent/accused has failed to appear before the investigating agency. Stop. Para. The respondent accused had also filed a criminal petition registered as Criminal Petition 1 of 2025. Stop. By an order dated 8/12/2025, passed in Criminal Petition 1 of 2025, this court had observed that the respondent accused was directed to appear before the investigating officer, but he had failed to do so in compliance of the order of this court dated 24/11/2025, passed in Criminal Petition 1 of 2025. Stop. The counsel for the respondent/accused submitted that the petitioner/accused was suffering from melena, MELENA, and because of his ailment, he could not appear physically before the IO, and that he is now ready to extend his cooperation with the investigating officer. Stop. This court had therefore imposed a cost of rupees 10,000 on the petitioner/accused to be paid to the complainant. Stop. The Criminal Petition 1 of 2025 has been finally dismissed
By order dated
by
10
this court by an order dated 10/2/2026. Stop. Therefore, learned PP submits that in order to continue with the investigation, the presence of the respondent/accused is necessary, however, under the protection of the anticipatory bail order dated 28/2/2025, the respondent accused has failed to appear before the investigating agency, and the investigation is unable to progress any further due to the failure of the accused/respondent to appear before the IO of the case. Stop. Learned PP has therefore submitted that The investigating agency on several occasions have tried to contact the accused slash respondent, but he is not responsive and does not receive his calls any further and does not receive the calls any further. Stop. Learned PP has relied on the case of, and then you just give some case laws, okay?
Tomorrow,
relied
tomorrow.
relied on the case of dash dash dash, you leave some gap. And then next para, in view of the submissions made herein above, Learned PP has prayed that the anticipatory bail, why two orders? Pre-arrest will not count actually. I mean, the interim will not count, it will be the final order only.
Yes.
Therefore, praise that the anticipatory bail order dated 28/2/2025 passed in the anticipatory bail application number 5 of 2025 may be cancelled / revoked. In the interest of justice. Stop. Para. The instant application was filed on 10/12/2025. Thereafter, the applicant has taken steps for service on the respondent through speed post. Stop. However, the same had returned unserved, and therefore, by an order dated 19/2/2026, the learned PP was given another opportunity to take fresh steps for notice on the respondent. Stop. There, subsequently, the learned PP took fresh steps on the respondent by way of speed post. No, on the last occasion you said that it was taken through Duliajan police station. Nah?
Yes, that one. Yes.
This is they had taken steps.
Yes,
Okay,
yes,
okay.
my lord.
Learned PP also took steps for notice on the respondent through the Duliajan police station, Assam. Stop. Subsequently, the applicant has filed a compliance affidavit showing the notice, showing the service of notice on the respondent through speed posts taken by the Duliajan police station. And the same shows that, and the tracking report shows that the delivery has been successful on 25/4/2026. So, in spite of due service of notice, the respondent has failed to appear before this court and is therefore, the matter is therefore heard in his absence. Stop. Para. The anticipatory bail was filed first or the criminal petition?
Anticipatory bail was filed first.
Then after it was disposed, the criminal petition was filed.
Yes, my lord.
It is seen from the records that the respondent / accused had preferred the anticipatory bail application being registered as AB/5/2025. Stop. The respondent was granted an interim protection by this court on 11/2/2025, and thereafter the interim order was made absolute and the AB 5 of 2025 was disposed of by this court on 28/2/2025. Thereafter, the respondent filed the criminal petition 1 of 2025. Praying for quashing of the FIR and the proceedings against him. Stop. On 24/11/2025, this court in criminal petition 1 of 2025 directed the respondent/accused to appear physically on 3/12/2025 at 1 p.m. But he did not comply with the order of this court. During the pendency of the said criminal petition 1 of 2025, the investigating officer had issued several notices on several notices to the respondent to appear physically on 2/6/2025, 23/6/2025, and 21/7/2025, However, the respondent failed to appear before the investigating agency. Stop. In fact, in the criminal petition 1 of 2025, this court had accorded sufficient opportunities to the respondent to appear before the investigating agency in its various orders. You have not enclosed these orders, this 29A, 23-9.
Yes.
You have not enclosed, no? You should have enclosed actually. In its various orders dated 29/8/2025, 23/9/2025, 13/10/2025, and 23/10/2025. Stop. However, by making various excuses of health issues, the respondent failed to appear before the investigating agency. Stop. Therefore, by an order dated 24/11/2025, this court in criminal petition 1 of 2025 granted one last opportunity to the respondent to appear before the IO on 3/12/2025 at 1 p.m., failing which cause shall be imposed and that necessary order shall be passed. Stop. Accordingly, by the order dated 8/12/2025, this court had imposed the cost of 10,000 rupees on the respondent as he failed to comply with the directions of this court. Stop. I have also observed that I have also taken note of the fact that the criminal petition 1 of 2025 has finally been dismissed on 10/2/2026. Stop. In view of the dismissal of the criminal petition 1 of 2025, the respondent / accused has a bounden duty to cooperate with the investigation and to appear before the investigating agency as and when summoned. Stop. However, responding. Stop. The conduct of the petitioner, respondent during the pendency of criminal petition 1 of 2025 has also been noted by this court. Inasmuch as in spite of the direction of this court to appear before the IO, on several occasions, the respondent failed to appear on some pretext or the other. Stop. Is this the case where court directed for security?
Yes, my lord.
To bring him and
Yes,
all that?
yes. Even then,
The
we
problem
was
is
not-
you have not annexed those orders.
My lord, since it was reflect in the order dated 18/12/22, that is why I have not enclosed. Last order, last page in my IA, my lord, page 25. In the second paragraph, it already reflect in the second paragraph.
Where? Page?
Page 26 of my IA, my lord.
No, here, no, that giving security and all that, that is not here.
Only the date has been mentioned, my lord. Yeah. Even the
No. In your pleadings also you have not mentioned,
yes, my lord.
That is very important actually, because in spite of the court directing that security should be given to him, he did not come. No, since you have not enclosed it, I cannot put that also. Acha, last line. That he failed to appear or something. Several. From the conduct of the respondent / accused, this court is of the view that the respondent has failed to comply with the orders of this court and has failed to cooperate with the investigating agency. Accordingly, the anticipatory bail granted to the petitioner, to the respondent / accused by order dated 28/2/2025 in AB/5/2025 is cancelled. Application stands disposed.
Much
You
obliged.
supply the judgment.
Okay, my lord. I'll supply tomorrow. Much obliged.
What is this? No, he has paid for cancellation. So this IA will be disposed. IA stand, no, nothing to do with the AB is already disposed long time back. IA stands disposed.
For orders, item number 18.
This is the one I think.
Yes,
infringement.
Lordship. This IA is filed for the implement of the new respondent.
New PHE.
Yes, as respondent number 4.
The instant IA has been filed praying for implement of Sri Zarantung Izung, Zarenthung Izung, IAS, Secretary to the Government of Nagaland, Department of PHE, as respondent number 4. Stop. Para. Learned Counsel, Ms. Atsula Kips. Stop. It is stated by the petitioner that the connected civil original contempt petition number 30 of 2025 is pending before this court. Stop. During the pendency of the said contempt petition, the respondent number 2, Shri Monbemo Patton, who was the then secretary, Department of PhD, has been transferred, and then a new incumbent, i.e., Sri Zarantung Izung IS, has taken over the said post. Stop. It is therefore become necessary to implement the new incumbent secretary of the Department of PHE as respondent number 4. Stop. Accordingly, it is prayed that the application may be allowed, and and Sri Zarantung Izung IS may be impleted as respondent number 4 in the civil original contempt petition number 30 of 2025. Stop. Para. I have considered the submissions made by the Learned Counsel and produced the pleadings. Stop. The instant application is allowed, and the petitioner shall take steps to file an amended cause title incorporating the name of Mr. Sri Zarantung Izung IS Secretary as Secretary to the Government of Nagaland PhD Department as number 4 in the civil original contempt petition 30 of 2025. So the amended cause title shall be filed within 1 week from today, and the petitioner shall take steps for service on the newly impleted respondent number 4 by speed post as well as usual process within within 1 week from today.
Lordship, this is your Lordship, may I also be allowed to take steps through Dusty service?
Through Dusty?
Yes,
Okay, as well as
registered
Dusty.
as well as Dusty.
As well as Dusty. Application is disposed.
Obliged.
Then in the main COP 30 of 2025, you say, in view of the IA filed in the instant petition, IA number 103 of 2026 filed in the instant petition, lists the matter after 2 weeks. Okay.
Much obliged.
Unlisted motion, item number 24, NSA 1 of 2026.
May I please your lordships? Am I being audible, my lord? My lord, this is a miscellaneous first application which we have filed against the order dated, my lord, 27/3/2026, which has been passed by the learned district judge at Mon, my lord. And if your lordship kindly see, we have filed a suit for, my lord, specific performance of contract and, my lord, other reliefs. Along with the suit, we have filed a petition for injunction, and a temporary injunction was granted, my lord, which your lordship will find at page, my lord, 40. Not
Yes.
the type copy starts from page 39A, my lord, and the operative part, my lord, finds at, my lord, page 39O. That is before page number 40, my lord. The page previous to page number 40.
Yes.
Has your lordship got it, my lord?
Yes, yes.
So there I may read paragraph 21, my lord. It says, consequently, this court holds that at this stage that sufficient grounds exist to issue an order of ex parte ad interim injunction, thereby waiving the necessity to provide notice to the OPs at this stage, as the balance of convenience lies with the petitioner. It is concluded that an order to restrain and prohibit the defendants along with their men, agents, servants, etc., from dispossessing the petitioner from the scheduled plot of land shall not undermine justice during the pendency of the main suit. The ex parte ad interim order is specific in nature. The opposite parties are restrained from disposing the petitioner from the scheduled plot of land in any form or manner in the next date on which the opposite party will appear and file their written statements. This order being ex parte and ad interim will remain in force in the next date and will be further considered on the date so fixed. So, my lord, this was purely a temporary order, my lord, and it was, my lord, enforced till the next date, which was fixed, my lord. That was 25th of March 2016. Now, what happened, my lord? On, my lord, 19th of February, the Deputy Commissioner Mon, my lord, he issues a letter to the district judge, my lord. That, my lord, a reference to that letter, your lordship will find in page 21.
Page
That is
21.
21. That is the impugned order, my lord. May I read the order, my lord?
Yes.
Latwang Konyak, the petitioner present through his learned counsel Naufe Konyak advocate Y.P. Gupta and Chupina Suni appeared before the court today and filed a wakalatnama for the opposite party Mopa Konyak and Yongyak Konyak. Accepted. In the meantime, received a letter number DC so and so dated 19 February 2026 addressed to this court from Deputy Commissioner Mon, who is also the district revenue cum land settlement officer, stating that the same case is presently pending adjudication before the court of Deputy Commissioner Mon. I have gone through the letter and also perused the case record at hand and satisfied. This case relates to the same parties and the same matter in issue, which has previously instituted in the court of Deputy Commissioner Mon, who had jurisdiction and competence to try the case. In view of the above, it is very difficult to further proceed with the case. Accordingly, further proceeding in the case is stayed, and the injunction order dated so and so passed by this court stands vacated, my lord. Now, my lord, the case that comes up for consideration before your lordships is, my lord, whether, my lord, the deputy commissioner, my lord, of a district, who is, my lord, admittedly a revenue officer, could have written a letter to the district and session judge, my lord, and, my lord, could have reminded her as to what is the extent of her powers and, my lord, position, my lord, as per the CPC. That is the question to be decided, my lord, by this court. And, my lord, for the purpose of, my lord, bringing in the provisions of res judicata under section 10 of the CPC, my lord, it says that, my lord, it has to be a suit between the same parties with the same reliefs between two different courts. And, my lord, if your lordship kindly consider the fact that even if, my lord, there was some petition pending in the court of the, my lord, in the customary courts, my lord, that could not have been a petition, my lord, for, my lord, specific performance of contract and, my lord, the reliefs of declaration which has been sought for in the suit, my lord. So that being so, my lord, the principles of res judicata is not applicable in the case, my lord. And moreover, in the suit itself, my lord, there is allegation that, my lord, the deputy commissioner has usurped his powers and has interfered, my lord, illegally into the proceedings and is somehow interested in the matter. And that being so, my lord, kindly see what was, my lord, the proper on the part was that, my lord, the respondent, the defendants who were appeared in the suit on day, they would have filed a petition saying that, my lord, the petition is barred by res judicata or whatever it is. And thereafter, on the basis of that petition filed, we'd have been given an opportunity to respond. And accordingly, on the basis of that opportunity to respond, my lord, the court would have heard the matter and then decided, my lord.
No, that
Now,
is
my
the only ground. That is the only ground, opportunity of being heard.
yes,
Because
yes,
against the order of the district customary court, appeal
my lord.
lies with the DC.
Yes,
Appeal,
my lord. But then the question is, my lord,
that,
there was no
that is
appeal
as
before the
per the
district.
rules. As per the rules of 1937,
My
uh,
lord,
appeal lies to the DC,
my lord.
and that is only proper. But the thing is, you were not
Yes,
given an opportunity. That's all.
opportunity and, my lord, if your lordship kindly permits me, there is a case, my lord, of this honorable court. That is the case of, my lord. Just give me 1 second, my lord. My lord, that is the case of, my lord, civil revision number 6, Kohima, oblique 2015. The parties is, my lord, P. P. Vihio Awomi versus Mrs. Putoli Awomi. In that case, my lord, the reference has been given in another case, my lord, where it says, my lord, from the contents of Rule 24 and 31 of the Rules for Administration of Justice and Police in Nagaland, Third Amendment Act 1984. Given above, there is no doubt that village councils do still enjoy certain powers to adjudicate civil disputes, particularly in matters relating to customary laws and fair. Their decisions are appealable before the Deputy Commissioner or his assistant. Further reading together of the minutes of the meeting held at the residence of the Honorable Chief Justice of the Gauhati High Court and the notification issued by the Department of Justice and Law, Nagaland, it appears that decision for total separation of judiciary from executive in phased manner has been taken and implementation of the same has been started with the district of Dimapur. In view of this change that has taken place, the power of Deputy Commissioner under Rule 31 of Rules for Administration of Justice and Police in Nagaland has to be understood as transferred to the district judge specially in respect of the district of Dimapur. Therefore, the learned district judge Dimapur should have admitted the appeal and decided the same on merit. So, my lord, thereafter, my lord, these findings are there. So, my lord, it is the categorical finding of this court, my lord, that when the separation of powers has come into being, now, my lord, the deputy commissioner now does not, my lord, hold the power to as an appellate authority, my lord, against the orders. And moreover, my lord, there is no appeal, my lord. If your lordship kindly go to the genesis of the case, my lord, and call,
But as far as customary issues are concerned,
my lord.
applies to the DC because
Yes, yes, my lord.
whether it goes to the DC or whether it goes to the district judge
My
is
lord.
still under consideration by a division bench. It has
Yes,
been referred. It has been referred.
I know. That is the case, my lord.
That is
22,
still
my
pending.
lord. Yes, my lord. That is 22.
As for now, Learned Council, listen to
That
me.
is
Yes,
52.
as for now, we will issue notice. We
Yes,
will
my lord.
have to examine. Okay, and
Yes,
then
my lord. Yes, my lord.
we will stay the impugn order. That's
Yes,
all.
my lord.
Yes.
And my lord, I have filed an interlocutory application also in this respect, my lord, that the original order dated 10 to 2026, which was passed, restraining the opposite parties from my lord taking over my lands forcefully, that may be invoked, my lord.
No, no. Once the impugn order is stayed, the original order will be
That
resurrected.
that 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 my lord clarification may kindly be given. That's my humble prayer, my lord.
No need. The instant appeal under Order 43, Rule 1, read with Section 151 of the CPC, has been preferred against the order dated 27/3/2026, passed by the Learned District Judge Mon. Uh, Learned District Judge Mon, staying further proceedings in the this is title suit in the
Yes, my lord. Title suit number 1 of 2026, my
1 of
lord.
2026 and
And
Miss
the connected,
and
my lord,
Miss
Miss J number 1 of
J
2026.
case number 1 of 2026. Stop. Uh, para. Heard learned counsel for the petitioner, Mr.
G
Gautam
Chaudhary, my lord. G
Chowdhury.
Chaudhary.
G. Chowdhury, assisted by and also
Now for Konyak.
Mr. Medover.
He is here, my lord. His name may be recorded, my lord.
Yes, yes, and also Mr. Medover. Stop. Para. The case of the petitioner herein is that by an order dated
10 to 26, my lord.
by an order dated no, the original order, the first one,
10 to 2026, my lord.
10 to 2026,
My lord.
the learned district judge Mon had granted an ad interim injunction in favor of the petitioner in Miss J case number such and such, the earlier one,
1 of 2026, my lord.
2026. Stop. By passing the said order, the said injunction order, the learned trial court held that sufficient cause grounds existed to issue an order of ex parte ad interim injunction, and thereby notice was also issued to the opposite parties to appear and file their written objections, and the matter was fixed on 20
5th of March 2026.
2026. Stop. Thereafter, the learned district judge Mon, upon receiving a letter from the deputy commissioner Mon, Nagaland, dated 13th February 2026,
19 February.
dated 19 February 2026, passed the impugned order dated 4/5/2026.
Number 27 3 2026.
Where is that?
Page
Impugned
21.
which
21, my lord.
oh, okay, yes. Passed the impugned order dated 27/3/2026. by which the learned district judge held that the case relates to the same parties and the same matter in issue, which is previously instituted in the court of Deputy Commissioner Mon, who has jurisdiction and competent to try the case. Stop. The trial court held that further proceeding of the case is stayed and the injunction order dated 10/2/2026 passed by this court stands vacated. Stop. Learned counsel for the petitioner submits that this impugn order dated 27/3/2026 was passed without giving the petitioner an opportunity of being heard, and also states that and also states that the issue of res judicata will not arise in the instant case as the learned trial court / district judge Mon is the competent authority to
Indicate upon the prayers made in the suit, my lord.
to entertain the appeal against the order of the Dobashi's court.
No, my lord. No, my lord. That's not that. To adjudicate upon the prayers for specific performance and declaration of right title and interest, which has been prayed by the plaintiff before the court, my lord.
No, but the trial court says that it is an appeal against the order
No,
of.
no, no. It's not an appeal. The DC says that he is, my lord, entertaining an appeal, but in fact there was no appeal in the DC before the DC, my lord.
To entertain is the competent authority to the district judge Mon is the competent authority to entertain and adjudicate a matter of declaration of title, rights, title, and interest.
Interest as well as specific performance of contract.
Specific performance of contract. Stop. Issue notice returnable in 4 weeks. So the petitioner shall take steps for service on the respondents by speed post as well as usual process within 3 working days from today. Stop. In the interim, the impugn order. Where is your prayer portion? Where is the prayer?
My lord, it's in the separate interlocutory application, my lord. It is in the IA, my lord. IA number 117 of 2026.
In the interim, the impugned order dated 27/3/2026 shall remain suspended till the next returnable date.
My lord. And my lord, that operative part of the order dated 10/2/2026, that will continue, my lord. Only that line, my lord.
No need.
No, because, my lord, now after being vacated, there is no injunction, my lord. So the injunction is a specific order, my lord. So only that line, my lord, that the operative part of that order dated 10/2/2026.
No, see, when we stay the impugn order, then automatically the injunction is revived.
My lord, they will not construe it to be like that, my lord. They will construe that because the injunction was already vacated. Now there is no order, so they will be proceeding, my lord. That is my humble request before your lordships, my lord. Only that line, that the operative part of the order dated 10/2/2026, that will remain in force till the next day. Only one line, my lord.
Okay, then after the last line, the shall remain suspended and the operation of the
The operative part of the original order dated 10/2, my lord.
wait. And the order of ad interim injunction issued white order dated
10/2/2026, my lord.
order dated that first order
10/2/2026.
2026
Will continue, my lord.
shall remain or shall continue.
Yes, ma'am.
Then
I am deeply obliged, my lord. Thank you so much.
of the order passed in MFA such and such, the IA stands disposed.
Yes, ma'am. I am deeply obliged, my lord.
Yes.
Lordship, item number 20 it did not
Hearing
reach
matters,
today.
I think we won't be able to take up today. Because this
That's
court
why
is not
I
sitting.
have come from Guwahati. So on last
Tomorrow?
occasion also, we either some of us were not there. So it may be fixed on 9th, next Tuesday.
You don't want to stay back? Otherwise, we can take it
Difficult
up
because I have
tomorrow.
already booked my tickets.
Oh, okay. Item 20. On the prayer of the parties, list the matter on when?
9th, next Tuesday. It may be listed in top of
9 June. Okay.
9
June for hearing.
Lordship, if it can be listed as first hearing
First
item on
hearing
9th.
matter.
Because if
At the top of the hearing
yes,
list.
yes,
Top
yes.
of the-
Okay.
And item
And
22,
22?
if it can kindly be listed this Friday.
No, not Friday. Thursday.
Thursday, my lord.
List on Thursday. Item 22. Yes.
Thank you.